Welcome, I'm Dr. Drsandhu from Business Management and Research channel. It's a project of the RISE. Kinds of jurisprudence. Jurisprudence or legal theory is the theoretical study of law. Scholars of jurisprudence seek to explain the nature of law in its most general form and provide a deeper understanding of legal reasoning and analog. So first one is analytical jurisprudence, historical jurisprudence, and ethical jurisprudence. Analytical jurisprudence. It analyzes the prevalent law, that is, the principles of law as these exist now. It also studies theory of legislation, precedent and customs, and study of different legal concepts such as property, possession, trust, contract, negligence, etc. Scope. It analyzes the basic principles of civil law. It does not pay any attention to the evolutionary process and their ethical aspects, that is, whether they are good piece of law or bad one. We can say that analytical jurisprudence does not consider the historical and ethical aspects. Its scope can be underlined as given below. Number 1, an analysis of law. Number 2, treatment of a complex idea or concept in its elementary subdivisions. Examination of relations between civil law and other forms of law. A study of the legal source of law. An investigation of the theory of legislation, precedent and custom. Classification of the different subdivisions of corpus juris or the entire body of law which reason therefore. A treatment of rights, their kinds, classes, their creation, transfer and extinction, dealing with legal liability, its kinds, extent and incidence. To investigate such legal concepts as property, possession, trust, contracts, persons, intention, motive, negligence, etc. Historical jurisprudence. It studies history of law and evolution of law over a period of time and also amendments, introduction of new principles of law. Scope. It studies the principles of law in their origin and developments that take place over a period of time. We can say that it gives the past history of important existing legal conception and principles of a particular system. For instance, the origin and development of the nature of private property, of individual ownership of contract. The object of historical jurisprudence is to vindicate the earliest of mankind as they are reflected in ancient law and to point out their relation to modern thought. This branch is not the same thing as legal history. Ethical jurisprudence. It deals with the law that should be in an ideal state. It lays down the different purposes which should be fulfilled in an ideal state. It studies the modification in the existing law in order to achieve these purposes and objects. The main object of ethical jurisprudence is the attainment of justice. Scope. It deals with the law in the ideal state as it should be. Law exists to fulfill certain purposes. It is for this branch of jurisprudence to lay down what those purposes are and whether they are fulfilled by the law existing at any given time. It considers the modification necessary in the existing law so that it may fulfill the objects for which it exists. The other two branches are concerned with an analysis of the law as it is or has been without being concerned with its adequacy. Thank you very much. I hope today's video will help you to understand business and labor laws. Subscribe for upcoming videos. Best of luck.